settled in. So welcome, everyone. Good afternoon. Again, it's Kevin O'Neill from Driver Tret. Welcome to this final session on claims management for the City of Toronto construction agreement. I'd like to just pass the microphone over to Patrick Young, the City of Toronto, for just a moment.
Sure. Thank you, Kevin. ECS, in collaboration with Driver Tret Canada, has prepared a claims management manual for use by all project managers and other project participants on ECS projects. Driver Tret is a multidisciplinary consultancy which provides specialist commercial management, planning, scheduling, project management, and dispute resolution support services. Its expertise supports the delivery of major projects worldwide and bridges the gaps between the construction, legal, and financial sectors. Driver Tret provides client-focused services, providing complete commercial solutions for all aspects of the engineering construction industry. In support of the rollout of the new claims management manual, Driver Tret will be presenting a detailed look at claims management over the coming months. Kevin O'Neill, Country Manager, will present an overview of claims management and claims avoidance with a special focus on schedule delay analysis. Kevin has been involved in the construction industry in an assortment of roles since graduating from McGill University. Kevin started with a consulting structural engineering firm, and he was the site structural engineer during construction of BCE Place in downtown Toronto. Kevin later became a project manager for Scotiabank Real Estate, building and renovating branches and data centers across Canada. He moved to the construction manager for the T1 Terminal 1 new at Pearson International Airport, where he was responsible for a number of structural steel, concrete, and artwork projects. Kevin later moved to a general contractor and construction management firm and a structural steel fabricator. He joined Driver Tret when it first opened business for Canada in late 2014 and has been country manager since early 2020. So then if you can go to the next slide, Kevin, please. Thanks. So we're going to do a land acknowledgement. So we acknowledge the land we are meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabeg, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis people. We acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. Okay, thank you, Kevin.
Thank you very much, Patrick. Just a brief outline of what we'll be talking about today. Each of the sections of the presentation is tied to the manual, final copy of which, or final version, which will be issued fairly shortly. I'm joined today by my colleague Denise Letizia in our New York City office. Denise will be monitoring our chat function. Question and answer in this application is through the chat function. So if you have any questions that come up along the way, please use the chat function to send those questions in. Denise will sort of collate those questions, and I'll have a chance at the breaks to take a look at them and get them answered. We have a tremendous amount of information to go through today. Over the next 3 hours, we'll have two breaks, two short breaks within that period. And we have a couple of poll type questions looking for some input from you and to help us with the presentation. Again, the question and answer please feel free to send some questions in. Might not get all of them answered during the presentation. We will be collecting all of the questions, and probably within the next few days, we'll answer those, every question that has been put out through the 4 presentations, so that you can see what has been going on and get a little bit more background on claims management. The training is intended to highlight some of the important aspects of the manual itself, give you some more background on how claims should be managed. The manual in this training are not intended to make you all claims management experts. We'll touch on many aspects of claims management in consideration of the new ECS contract that you've been using for about a year now. So let's get started. Suppose we should start with a definition. As you see here, a claim definition that comes out of your agreement, the new ECS agreement, is any and all actual, threatened, or potential claims, demands, proceedings, complaints, grievances, actions, adjudications, litigation, applications, suits, and losses in respect of the foregoing matters. So it has to do with all of these issues that may come up within the contract and the losses that may be attached to those. Why do claims occur? This is, it's a simple reflection of the complexity of an average construction project. A party will inevitably incur losses to varying degrees over the course of the project through no fault of its own. Purpose of notifying another party of a claim is to begin the process of making a party whole. A claim is, in effect, a request to the other party for an equitable adjustment of matters. The end result of a claim should put a claimant in a position no better than if the situation that gave rise to the claim didn't occur in the first place. Certainly, a claim should not represent an unjustifiable enrichment of either party. There are as many causes of claims as there are projects. Some circumstances that give rise to a claim are generally within the party's control, such as in the cases of poor documentation, planning, or communication. In other cases, the circumstances are beyond the party's control. Parties are generally not able to address situations outside their control, natural disasters, changes in government regulations, etc., that can be foreseen, but not specifically quantified within the contract. Claims generally fall into 2 distinct categories: an extension of time claim and costs. Of course, these categories are not mutually exclusive. Even a claim for extension of time can be, in effect, a claim for cost. We see some of these, here we go, some of these, prolongation costs, and these are the time-related costs related to basically being on site longer. Some of them are, non-time related claims, disruption claims, where perhaps a party has had their work disrupted, but it does not actually extend the time for the project. This will happen to subtrades that are not doing work that is not on the critical path. Interference claims where 2 parties are working, trying to work in the same area at the same time. In the end, as we said before, claims are often a combination of the 2. Since you're working for an owner, we're most interested in claims that are caused by owners' actions or inactions, or for matters where the risk is borne by the owner. Claims that are owner-caused are often the result of change or excessive change or existing conditions, things like that. Contractor-caused claims are generally related to delayed completion or substandard work. Often there are issues in the contract, clauses in the contract that permit the owner to assess liquidated damages against the contractor for delayed completion or not meeting specific milestone dates prior to completion. Claims for poor workmanship and the cost for repair or replacement, or for the inability to occupy a space or to use an improvement, would fall under these categories. Consultant-caused claims can fall under third-party claims. Let's say a contractor claims against the owner that the design documents were not sufficiently clear, causing lots of RFIs and changes to the work. The owner might claim against the consultant for compensation. Liability. The a more formal definition of liability is an obligation or responsibility owed by one party to another by law. Liabilities under the contract fall into three main categories. There's contract liability, statutory liability, and tort liability. The most common of these are that in the construction area are contract liability and statutory. Tort liability generally refers to things that are possible criminal activity and is really outside the scope of this manual. A contract liability claim is an assertion of the rights arising from the terms of the contract and essentially comes in one of two forms: express or implied contract liability. Express contract liability refers to matters that are plainly written in the text of the contract documents. Implied contract liability stems from longstanding or commonly held understandings that come from both the customs and practices of the construction industry and from past decisions of the courts. Therefore, such liabilities are implicit in the contract. Statutory liability is a liability imposed by law or statute. Examples of statutory liability are fines for exceeding speed limits. The key to statutory liabilities is that it is not possible to negotiate away these liabilities in your contract. A contract breach. Contract breach occurs when a party to the contract fails to act in accordance with one or more of the express or implied material provisions of the contract. Through all of this liability, the party that is making the claim needs to substantiate that claim. And there, basically, sort of two rules to that. Is the party that asserts the claim needs to prove its claim, that is, the party claiming the item of damage, cost, expense, or value has to support its claims with evidence. Can't merely say, I lost money, therefore you owe me. And the standard of proof in this is not like on TV where it's beyond a reasonable doubt. It just needs to be established as being correct on the balance of probability. Substantiation itself, let's say determining costs of materials for additional work requires production of invoices for some project-specific costs. Project costs that can't be specifically identified. There are a number of formulas to be used for calculating things like head office overhead and those sorts of things. And we'll touch on those later. Warning signs. Claims don't just come out of nowhere. There are very often warning signs that if people are aware or have their eyes open to it or their ears open to it, they may identify things that come up and say, geez, I better watch out for a claim. Just touch on a few here just to get your mind thinking about these. Some of these are, a fast track project, which is basically where certain parts of the design are finished and work is beginning before the rest of the design is finished. Things like incomplete design or inadequate site investigation. A win-lose mentality between the parties can lead to claims coming up later. Excessive scope change, unfeasible schedules or budgets. Sometimes it's owners that have unrealistic expectations in terms of cost and time, or they fail to properly plan the project. I've seen some projects that are essentially built by change order, where the design is so incomplete at the start of the job that it's just one change order after another. Sometimes, consultants don't properly coordinate the drawings. Perhaps they don't respect time constraints. Sometimes, to be honest, in the business, and this is a change since I've been in the business, is sometimes there's basically not enough not enough money in the consultant's contract to pay for proper work. And it's a shame that, that basically it comes down to a low price. Generally you want really good quality design. And although it's more difficult to prove anyway in the end, that a better design and better documents usually provide a more cost-effective and more timely project result. So if I'm going to put up a question here, the first poll question, and just bear with me as I find that. So we have surveys. We have the first question we're going to put up, and going to ask you so there's a question here: is what is the greatest cause of claims in your experience? In your experience in the is it unknown site conditions or a significant change in design during the project? Or is it interference from other contractors or other contracts? Let's say, I understand many of the facilities you have, will have many different contracts going on at the same time. Or does it, say fall under other? So if we can just, for a few seconds here, just take a little thought and, let us know what your thoughts are on, what the greatest cause of claims in your experience. And that could be with while you're working with the city or prior to joining the city. Okay, so we'll just give this another couple of seconds here. Okay, any late comers? All right. So at that point, I think everybody's got to vote in. So we have let's say, roughly, there it is. 2/3 of the people think that in their experience has been unknown site conditions, and roughly 1/3 of the folks, it's a significant change. So we'll end the voting there and close this. And so I'm going to, so let's get back to our presentation. Just a few more clicks. Okay, there we go. Again, so our presentation is laid out as to follow the chapters in the new manual. So now we're going to talk about claims and how it relates to your agreement, your new agreement, the ECS agreement. So your construction agreement that's basically being, I would suspect, is being used on pretty much every single project now, given the new Ontario Construction Act that really came into force, the revisions that came into force a couple of years ago. And I understand most of your projects really are sort of a 1 year, year and a half, 2 year time frame. So in that construction agreement, claims are addressed in section 7.7. And we're going to refer back to that quite often as we go through this. In particular, section 7.7 outlines various notices and other requirements that are related to that follow through your contract. First is, of course, the matter of claims notices and timing. There might not be anything more important than that. Second is the substantiation requirements. What is required for the contractor to substantiate its claim. Third is the matter of an interim claim and what content is required. Sometimes there are things that go on for a long period of time through a contract, and those are identifies additional information that needs to be provided on an ongoing basis. Lastly, or one of the last things is that the contract administrator can actually request additional information. It's not necessary to simply say this is all the information that exists. And they could go out and actively ask for more information. The last point that we have here is section 9.2 is the waiver of claims. In your contract, basically this occurs towards the end of the contract, either at the time of request for a substantial performance or total completion of the contract. And this is a certification, let's say, by the contractor that they have no additional claims to be submitted, or verifying that all claims that they may have been submitted at that time. It keeps, sort of from later on from having something show up when you think that, you finished your contract successfully. As far as notices, 7.7.1, the basis is the contractor is obliged to notify the owner within 10 days of the date that it became aware of the issue at the center of a claim. So this essentially gives the contractor some time to figure out if a situation that it has come across is causing them a problem, and do they want to submit a claim notice. Now, as soon as that notice is prepared and submitted, it's up to the
Hi,
contractor
Kevin. The
to
slides
keep.
are not showing.
Oops. Okay. Thank you. Let me. My apologies. Why is that not showing? Let's go back to this. Is that better?
No. Yeah, that's fine.
Okay. My apologies there. Okay, so 7.7.1, contractor is obliged to notify the owner within 10 days that it became aware of something that's at the center of the claim. 7.7.2 talks about keeping all of the necessary contract records that are needed to substantiate their claim. So that's time and material, change in the work, daily contractor records, those sorts of things. And that's all fairly well documented in your contract. But let's see what those the required contents of the claim notice, what the notice actually has to have within it. So identify what the problem is, indicate the date that the contractor first became aware, state the grounds. You basically refer back to the contract as to why there's a claim, why they're allowed to make that claim. Give sufficient evidence and detailed information so that the contract administrator can make some sort of assessment. And these are usually an initial assessment. Describe the work that is affected. Come up with an idea of what the changes to the contract time, what extension of time might be necessary. A detailed account of the amount claimed, the breakdown of the change in contract price. This might be a bit more difficult to identify if it's something with an ongoing issue. Details of mitigation strategies. How is the contractor mitigating the problem? Any other pertinent details? And identify and provide the contractor records. Again, if it's something that's ongoing, this will have to be done on an ongoing basis. An event of continuing effect, as we mentioned, sometimes these claims will have a continuing effect. In this case, the claim notice is effectively an interim notice. The expectation is that the party will continue to update the other party on the claim, giving updates on a regular basis as may be requested by the owner or by the contract administrator. 7.7.5, the contract administrator can request additional information if they feel that something's missing. So that allows them to quickly address the notice. You don't just want it to sit there. Now, 7.7.6 talks about a determination. It says that contract administrator should provide a determination within 90 days. I would suggest that's maybe a little bit long. You don't want to hold, yes, you don't want it to be a time frame that's so short that a proper assessment of the matter isn't made. On the other hand, this is in many cases could be many millions of dollars that are at stake, and the party wants to get an answer in as short a time frame as is reasonable. Again, 90 days is, I would say, is probably a bit long, but that is what's in your contract, and that's what both parties have agreed to. Some of you are probably familiar with many other different contract forms. CCDC2 is a standard contract form, stipulated price contracts. The OPS agreement, very much a unit rate based agreement. Just saying that your current agreement now in these sections, if you're looking for similar discussions or similar matters, you'll find those in the CCDC2 in these sections, and in the OPS agreement you'll find corresponding information in these sections. So just if you have some experience in those, that's where you would find them. We'll talk a little bit about risk management. One of the main functions of a contract is to allocate risk between the parties. Now, what many people don't realize is part of the cost embedded in a construction contract is the price paid for the contractor to take on risk. And that risk premium is paid by the owner, and that's embedded in the contract price. So let's just talk about risk quickly. You have external risks and internal risks. External risks includes things like changes in legislation, tax regimes, climatic conditions, general economic climate. Internal risks include, unpredictable site conditions, incomplete engineering design prior to the commencement of the work, those sorts of things. One thing is that the focus of the process of risk management should be the whole life cycle of the project, including aspects such as finance, construction, the environment, business case, those sorts of things. It's not solely the construction project. Quite often, you'll have provisions made in the contract for a risk register, and that's driven by risk reduction meetings, or early warning meetings, or something along those lines, convened to review risks, update that risk register, and track progress on identified risk issues. Ongoing risk reviews and update meetings might impact on the risk allocation in the project, and therefore should be carefully monitored to ensure that there is no significant transfer of risk from one party to the other without proper informed consent. Quite often, that transfer of risk may not be clearly identified as the project goes on, and it comes back to bite one party or the other or both towards the end of the job. It's easier to establish distinctions between design and construction risk when designs are undertaken by the owner, either in-house or by a retained consultant, and the construction to that design is executed by the contractor. So that's a typical, design, bid, build situation. If there are elements of specialist design with which a contractor or its subcontractor are involved, the contract needs to make clear the elements for which the contractor has responsibility. This can be in a full-blown design build contract, or perhaps there's some aspect of the work that needs to have special design within that. Something that comes to mind for me would be, design of post-tensioning slab within slabs and girders and the structural concrete sort of systems. Ongoing risk review and update meetings might impact on the risk allocation of the project. As we mentioned before, need to watch on that. In some contracts in other jurisdictions, the emphasis of managing and providing early identification and warnings of risk is carried through to the valuation of the compensation that's provided if the contractor should have given early warning but did not. Sometimes the contractor basically will have their recovery reduced because they should have known of something or should have done something early on. Many international arbitrations see arguments regarding the quantification of claims preceded by arguments just regarding notice, whether the lack of notice is a strict requirement under the terms of the contract and the applicable law. There's quite a number of cases in Canada where, as much as everyone has talked about issues during during progress meetings on the site and whatnot. When it comes to putting something in front of a judge, the judge will say, no notice was given. You're not allowed to claim for this. In the end, the root cause of many claims and disputes on construction and engineering projects is the failure to place risk plainly, and that's plainly, on one party or the other. Risk should generally be carried by the party best able to manage it. Things like building permit risk and subsurface condition risk generally fall to the owner, as the contractor usually isn't involved in the preparation of design documents. The owner, owns the land and is responsible for what's there. Contractors, of course, take on the risk that they will secure knowledgeable trades with sufficient resources to get the job done. So again, needs to be a clear, there should be a clear distinction of which party is carrying which risk. Claims often are created by questions regarding risk and which party is responsible for what. Whatever the contract used, it should address how risk is apportioned between the contracted parties in terms of the following aspects: the respective rights of the parties and the responsibilities of those two parties, the obligations they carry and the liabilities they have for the work. The degree of risk involved in certain key aspects of the project should therefore be assessed and respected, whether it is more economic for the owner to take a risk or for the owner to pay the contractor to take on that risk for them. This is a question that comes up. I don't know that you have seen this in your work, but certainly the idea of P3 projects, where the contracting industry has said that they understand how projects should run, and it is economical. It is more economical for, in our case, the province and sometimes the cities to pay the contractor or the consortium to take on almost the entire risk for the project. From somebody who's in the claims business, it is not as clear cut as that. And quite often we see claims where the P3 consortium is going back to the owner saying, hey, wait a minute, we didn't really want to take on all of this risk. Usually has to do with existing conditions and third-party utility contractors. That's pretty much where it always lands. Again, just want to mention, if you have any questions as we're going along, please use the chat function and send your question in to Denise, and we'll be able to look at it during the break and maybe get some of those answered afterwards. Chapter 4 of the manual deals with construction schedules. Every project needs a schedule. Construction schedules show the work that needs to happen, how long that work will take, and the order that the work must follow, the sequence of the work. A baseline schedule is a basis for managing the program scope, the time period to accomplish it, and the associated required resources. The baseline schedule is designated as the target project schedule in the ECS City of Toronto contract agreement, and is project performance and progress of the job is measured, monitored, and reported against that baseline schedule. The contract administrator should be particularly aware of the contractor's requirements, and that the contractor must advise the contract administrator of any revisions required to the construction schedule as a result of extensions of the contract time provided in Section 7, changes in the work, and provide an updated construction schedule reflecting such extensions. In this way, the owner can be kept informed in real time of any potential exposure to claims and changes. Once the project commences, the baseline schedule should be continually monitored to reveal when planned completion dates differ from baseline dates, and whether those schedule variances affect downstream work, resulting in corresponding variance in the as-built dates. The responsibility is on the City of Toronto project management and controls team to place the same to place a real rigorous framework of controls on the contractor and make sure that the schedule is monitored on a regular basis. What we often find is that the schedule that is prepared, or the schedule is prepared usually in order to allow for payment to proceed, quite often does not have the structure within it in the terms of durations, logical links between activities, resource loading if required. It really isn't there. It's just, to be quite honest, a pretty picture, and quite often cannot actually be used to plan the project as change to the project occurs. If everything goes completely according to plan, it's usually quite fine. But we all know that that's really not the case. We'll talk about the schedule and how it relates to claims. A properly prepared schedule should permit the continuous and transparent analysis of the original to actual performance. So comparing what was planned with how things are actually going. It should assist in the efficient use and coordination of the resources of the project to ensure the completion is achieved on time. A schedule should alert all parties engaged in the project of the required performance time of their functions and responsibilities. And a good project schedule will include everyone that surrounds that. So that includes consultants that need to look at submittals and whatnot. It includes resources for owners. At some point, they may need to assess change or assess certain aspects of the job as they go along. So that those things need to be addressed as well. Again, we see so many schedules that don't account for procurement by the winning contractor or preparation and submission of shop drawings and other schedules as things go on. Now, of course, contractors are going to use, pardon me, will use those schedules as a tool in their own claims management process. They'll use that schedule to provide the narrative, the story of their claim. The schedule can also be used to show where a contractor was delayed and provide some of the justification or substantiation of their claim. The schedule can also be used to support the quantification of damages in the claim. The schedule can also be used by the other party to the claim, that generally the owner, to refute whether the claim is valid or the story has validity. So regarding substantiation or validation, as I just mentioned, it's a critical tool in defending against a claim as well, or developing a counterclaim, going after the contractor or the claimant for delays or damages that it is causing to the owner. Effective management of a claim entails the user distinguishing the various types of delay that make up a claim and which ones would entitle the claimant to an extension of time to the critical path and which ones do not. Section 7.5 of the General Conditions addresses the matter of delay in the contract. The requirement for a properly constructed project schedule cannot be understated, as I just discussed, and as it will serve as the basis for creating or defending a claim for delay. What we find is that a project schedule is either A, poorly constructed, or B, rarely updated, and rarely properly updated, such that the schedules cannot serve any purpose in identifying and determining delay to the project. Contract administrators should be aware of the consequences of a poorly maintained project schedule. We often see where contract administrators either don't focus on the schedule enough, or they really don't understand what the schedule is telling them. We are at times brought in on large projects to do detailed analyses of construction of schedule updates, say quarterly or even monthly at times. And it's sometimes astounding to see the wholesale changes that happen to a construction schedule as the work goes forward. Key use of the schedule is quantification or valuation of delay. The schedule itself usually aligns pretty closely with the proposed budget that the contractor has starting off the job. Any impact on the schedule, therefore, of course, has a corresponding impact on the budget. Another example, resource loading, so the process of showing resources, is performed using a project schedule if a contractor is wise, so that the project managers can assess where the need is most urgent based on the sequence or phasing of the work. They know where their resources are being properly used or where they're being wasted, where there's crashing of schedules or crashing of resources where that produces unproductive work. Of course, damage calculations are frequently tied closely to budget and schedule, such as in the case of liquidated damages for late completion. They're just calculated on a cost per calendar day basis or per week or per month, as the schedule may see. The narrative forms the basis of a claim. It's the story that establishes the facts of the matter that has brought about the claim. Usually it's a fairly straightforward chronological telling of the events that transpired. We received this change, this happened, I was told to do this, then we went back and forth in a chronological fashion. The first inklings that something's going wrong are usually shown on a schedule, and only on a schedule that's properly maintained. I've been a project manager where there's tremendous pressure to not show that the project is slipping. I would suggest that having an accurate schedule is better than having a schedule that shows things are going well when they're not. Effective contract administration, you need to show the impacts of events as they occur, what the effect is on the schedule, and then allows you to raise a flag when something is going wrong. Of course, in the end, the contractor is going to use that schedule to show that something has gone wrong, and they'll be able to show where it's gone wrong, what activities have been affected, and why, in their opinion, they deserve to be compensated for their damages. Again, as I said, going through a lot of material here. If you have questions, please send them in. We'll take a look at them over the break and be able to answer a couple of them for certain. In the end, we'll be sending responses to all the questions as we go along. Chapter 5 of the manual deals with changes to the work. And there's a difference between changes and claims. It's a critical distinction in that a claim triggers a claim that triggers the changes section of the construction agreement is one where everyone agrees that a change has happened, and this is the resolution. Whereas a claim that triggers the dispute resolution sections of the contract, and that is in effect, an initiation of a formal disagreement. The contract administrator should be aware of treating the change with the same level of diligence as it would a submitted claim, as the claimant will themselves be aware that there's a remedy in the form of dispute resolution section of the agreement should the contractor feel that the change order has not been fairly considered. We find quite often that changes are addressed as far as direct costs, but contract administrators rarely allow for extensions of time. Partly that's on the contractor side in that they're not properly documented or don't have proper evidence to show that they are being delayed. On the other hand, quite often, I think it's contract administrators aren't prepared or aren't knowledgeable enough to address time. And what that does is at the end of a job that has a number of major changes to the work, at the end, the contractor says, and by the way, I've been delayed by 50 days. and this is my evidence, and it creates a claim that really could have been addressed at the time that the change happens. We spoke earlier about the criticality of the schedule, the need for its consistent monitoring and management. The contract administrator should be vigilant about any delay appearing on the schedule and take great pains to establish the root cause of the delay and who has the liability for the delay. So Section 7.5 deals with the risk that the owner and contractor have for any delay. The contract administrator should refer to this section when identifying a delay. What are the circumstances surrounding the delay? How would you categorize the nature of the delay? Was it due to the fault of the owner, or was it the result of the contractor's actions? Was it the result of circumstances beyond either party's control? Real-time analysis of the delay means that the owner will be effectively equipped and prepared for the inevitable claim, and it is inevitable, that will arrive in the wake of a delay to the schedule. Once identified and analyzed, there will be opportunity for the parties to mitigate the delay by accelerating the work by way of some other form of mitigation. Whenever a project is delayed, there needs to be a recovery plan. Contract administrator should note the contractor's general duty to mitigate when it comes to delay and damages to ensure that the contractors follow the recovery plan section carefully. Any applicable claim will be assessed on a that should have happened basis, and the claim should be reduced accordingly and proportionally. We talked earlier that the contractor needs to mitigate the damages, needs to address the issues that have come up. They don't have an overarching responsibility to spend every dollar they have. Section 7.5.9 says the contractor should use best efforts to mitigate the impact of any delay events, and that should be seen in what the contractor is doing on site. Liquidated damages. This is a basic process that to be honest, I was not involved in a contract that had liquidated damages until I was 20 years into my career. It wasn't something that came up in most of the building type projects that I was involved in. It's only when I started doing things that had industrial and process related issues there where liquidated damages came into play. Liquidated damages are a genuine pre-estimate of the direct damages both parties agree would be reasonably incurred because of a project's finish beyond that scheduled date for substantial performance of the work. And the phrase genuine pre-estimate is fundamental to the valid enforcement of liquidated damages. And that's brought up quite clearly in the City of Toronto agreement. Liquidated damages are not intended to be a penalty and are a reasonable and genuine pre-estimate of the actual damages that will be incurred by the owner if the contractor fails to achieve substantial performance in accordance with the requirements of the agreement. Basically that's, hey, if this part of the project is not done by this date, the next contract that follows, let's say, can't start, and therefore that contract will be impacted. And the estimate of that is $5,000 a day, $10,000, $100,000, whatever it happens to be. That's part of the contract, and that means that both parties have agreed that is that pre-estimate. Of course, if it turns out that pre-estimate is grossly over what the actual damages incurred would be, if a contractor did have liquidated damages applied, they could go to court and try to have those overturned. On the other hand, just the mere fact of having liquidated damages does not mean that is a cap on the damages that are paid. If in fact additional damages are incurred, an owner could claim against a contractor for additional damages over and above the liquidated damages. Chapter 6, notices. Notices are the first step in the claims management process, and perhaps the most important, in that this kicks off everything that follows. A notice serves to make the other party aware in real time of any problems that are occurring in the project. Notice is an essential tool of project management. By being made aware, the other party can now address the problem expeditiously with minimal impact to the project schedule and to damages. A notice allows, from a contractor to an owner, allows the owner, or provides an owner at least with an opportunity to mitigate the damages. If there's no notice, they don't have that opportunity. The notice serves as the contemporaneous, or as a real-time project record, and triggers the other contractual remedies that are in the contract. Of course, there are of course upsides and downsides to each form of notice. In most contracts, what constitutes a valid notice is often defined quite broadly to allow for most project intercommunications to act as valid forms of notice. Of course, that poses some issues. There's all sorts of documentation, emails, submissions, letters going back and forth, attachments. It could even be that a casual exchange is in fact notification. So courts may look at the exchange and deem that communication as what's called constructive notice. It's critical that a contract administrator be able to identify what constitutes a constructive notice to avoid missing opportunities for immediate mitigation matters. It may well complicate any future corresponding assessments. So constructive notice is a notice that's not expressly identified as such, as in it does not have a title on the top of it that says notice, but its form and content means that one party is giving the other party a valid notice under the terms of the contract. It's an implicit rather than an express notice. Similar to when a party's conduct, how they behave on the job, means that they are adhering to the contract implicitly rather than strictly. Things like when a party mobilizes its on-site workforce upon verbal instruction rather than a formal written notice to proceed. Contractual notice is a notice that strictly and expressly complies, both in form and structure, to the requirements of the notice section of the applicable contract. The City of Toronto construction agreement, let's just say for a notice to be valid, under a strict interpretation, says that subject to GC 1.6.3, the parties agree that any notice in writing is required to be given, or that may be given, can be provided in one of the following four methods that we'll talk about. So you have a notice in writing. How can you deliver it? Well, the fastest and perhaps most common way is through email. But email, you may have it as part of 50 or 100 emails that get sent throughout the day, and they might get lost in that. Registered mail is also an approved method of transmission. It's perhaps the most formal, but it's also rather slow. Courier, way back when, I remember when couriers used to go in and out of offices all the time with documents, important documents to be signed that were time sensitive. Hand delivered. If you're on a large project, let's say a project that has the contractors, an office compound, and the owner or the contract administrator has a trailer there, hand delivered, basically walking it from one trailer to another, is also approved. So within your agreement, you have four valid ways of transmitting that notice. Now, the timing of the notice, this comes up in many different aspects. And there are different timing regimes for different types of notice. In this particular case, 7.7.1, you have this if you don't make a proper notice, then the claim that you make down the road can be found to be null and void. we have just talk about one thing here. We seen earlier that contractor had 10 days to provide a notice, and the contract administrator had 90 days. 10 days to provide notice of claim. Contract administrator had 90 days to provide its determination. Clause 7.4.1 deals basically with subsurface conditions. Now, they have 5 days in this case to provide some sort of notice in writing. And the contractor has 20 working days after that to get back to them. So you'll notice in your contract there are different notice periods, different notice requirements, and different response requirements. And it's absolutely necessary that all the parties deal with these timing issues as they should, as prescribed in the contract. So I'm going to talk about claims and notices, how they go together. And that comes out of section 7.7 of the contract. We just mentioned and we just talked about timing. In general, related to claims, need to have that notice within 10 working days when the contractor thinks they have an issue that gives rise to a claim. Need to identify what they're actually talking about, what the issue really is, what the date is that they first became aware of that event or circumstance. Show the entitlement within the contract or otherwise of why they believe they're able to make that claim notice. And they need to provide sufficient information to allow the CA or the owner to properly consider that claim. So description of the work that's affected, the details of the change in time, if any, what mitigation strategies have been applied, and whatever pertinent information is required. So the contractor's determination. Again, we touched on this before. Again, it ties into notices. The contract administrator has 90 days to review the matter, prepare, and issue a determination. Contract administrator is the arbiter in the first instance of the contract. This determination becomes finalized if the contractor does not provide some sort of response to that determination, either by providing a revised claim notice or issuing some sort of notice of dispute as allowed under the contract. So this, so this process has, as you can imagine, is 10 days once you give notice. Then at some point, the full documentation of the notice will be provided, because most claims have some sort of ongoing effect. And 90 days, up to 90 days for the contract administrator to make its assessment. And 15 working days after that, the contractor must have either submitted a revised claim notice or started a dispute process, or they will have been determined to agree or basically not contest the determination. So chapter 7 of the manual talks about documentation. You'll all know real estate, obviously a hot topic in Toronto. Real estate is often said that the three most important things in real estate are location, location, and location. In claims and disputes, the three most important things are documentation, documentation, and documentation. The clear factual evidence is fundamental to a successful claim. Good records are a vehicle for clear factual evidence and help both parties, not just one party, but both parties avoid confusion while assisting in reaching agreements by establishing the facts, the roles, and responsibilities during the progress of the project. Poor quality in the project records represents poor factual evidence, which in turn represents serious difficulties for the parties in identifying the rights of the parties and the damage flowing from the breach of those rights, the breach of the contract. Experience in construction disputes demonstrates that the earlier the facts are established, the earlier the claim is likely to be settled. Too often, contractors can broadly demonstrate that something went wrong on their project, but because they have no corroborating documentation, they're unable to either identify the exact cause of the problem or prove that the claimed costs are directly attributable to that problem. Project documentation is one tool contractors do not use effectively. For example, good records of the events leading to and supporting a contention that a variation occurred, a change occurred, can mean the difference between settling a claim or a quotation there and then and waiting years to that argument before an adjudicator, a judge, or an arbitrator. Project record keeping procedures need to be geared towards managing large quantities of physical and electronic records. When good record keeping procedures are established and maintained, the contract administrators are often able to retrieve key information quickly and in a timely manner to respond to crises and manage problems at the time they arise. This reduces the need for forensic analysis of the project delays, and gets the matter solved much more effectively. So what does the City of Toronto Agreement say about documentation? Contractors should keep such contract records as may be necessary to support and substantiate the claim notice. And one of the things that they will do, perhaps because these have to do with, most claims have to do with site issues. So the contractor shall attempt on a daily basis to reconcile its daily contracting record with the records of the contract administrator. Of course, the reconciling of those records shall not be construed to be acceptance of a claim notice. People are quite often say, look, I want you to sign my day sheet. And people will say, no, I'm not going to sign your day sheet. Well, signature of the day time, the timesheet for the day doesn't mean that you accepted it. Simply that, yes, I saw it. That is the record. And down the road, you say, yes, that's the timesheet that was shown to me. This next phrase does come for your contract. If it is not possible to reconcile the daily contracted work records, those records shall not be resolved until there's a resolution of the applicable change notice. So basically it says, fine, we weren't able to figure this out then, we will address it later on. It is good, those records, and we'll talk about this later on, that these records be done at the time. The term would be contemporaneous or contemporary. So what sort of project records are we really dealing with claims? So, first is the, day-to-day routine communications that relate to those claims. And that's things like emails, formal letters, key verbal conversations or instructions, those sorts of things. You recall that FBI director who said he had a meeting with President Trump, and when he got back to his hotel room, he sat down and wrote up notes, that note to file. He couldn't write it while he was in his meeting, but he wrote it as soon as possible afterwards. Sometimes you need to sit down and write what those verbal communications were. Documents that relate specifically to claims in dispute. So, what are the crucial documentations? Things like, stop work orders, non-conformance reports, inspections reports, notices to proceed, other notices, and other formal documentation that's issued under the contract. Again, we spoke earlier about things like labor, materials, and plant, and the cost data that gets attached to those. What the charge out rates are for those sorts of things. All of that, what the buildup of hourly rates for labor. All of those records need to be available. In the end, if the project is delayed or disrupted, if there is a claim, contemporaneous documentation will become the source for evaluating, supporting, and successfully defining the issues of cause and effect in a delaying event or in what we would call a disruptive event, where some party is disrupted, but the overall project is not delayed. The documentation that the contractor has to actually develop its claim. So, and it goes right back as far as the tender, what was being asked of the contractor in the first place. So you have, the tender documents, the actual contract documents, what those contracts are in the end, once the tender price has been accepted. And the overall agreement negotiated. Construction schedules, and this means every schedule, not just the baseline schedule, but every monthly update as you go throughout the project. The project and site records. So that's who showed up on site, how many hours were they there, and that it goes back to all of the subtrades. The project documents. So these are yes, the contract, but also change notices, change orders, RFIs, supplementary instructions, those sorts of things, as well as things like submittals, shop drawings, that sort of stuff. And then there's the specific claim-related documents. Those are the documents that have to do with a specific issue. Hopefully the contractor has, if they've submitted a notice, they've then started tracking their costs and time related specifically to that notice using, let's say, unique or, slightly different cost codes within their estimating system or their cost control system. Now, just talking about the evidentiary weight of those project records. When we talk about claims, predominantly we want claims to be settled. Whenever a client comes to us and says, you need to help us with a claim, the number one goal is to get the claim settled. You don't want to go all the way through to arbitration or litigation. So people think, well, what is the evidentiary weight? I don't need to know this until I'm actually that far down the road. But if your records have these types of qualities or these characteristics to them, it will get you to the finish line that much faster. We talked about contemporaneity. That is, how contemporaneous are the records? Were they done at the time, or were they thought of later on? Neutrality. This is sort of a thing where one side can push one part of their argument, but if there's the good parts of their argument, but if they don't show the bad parts of their argument, the thing will tend to fall apart, and you start to question the other parts of the records. Approvals. So this is, are these documents part of a sequence where something is submitted and is approved or reviewed or agreed by the other party? Those stand up better than ones that are simply a submission with no response. Do you have a formal and consistent process for these types of documents, as in quotations for a claim? Is it a full quotation with a schedule attached? Is it properly reviewed, or is it sort of ad hoc or haphazard? First-hand records. Are these the actual first-hand records that happened that day? There's a lot more weight given to something, again, showing my age. We used to have communications on a 3-part form where you would write on the top, and the other 2 copies would be underneath, and it would be a carbon copy and go to all parties. Well, that is something that's firsthand. That will carry more weight than if somebody went back to their office 3 days later and typed something up. Security. This is something I haven't come across yet. I know some of my colleagues have, but the idea that somehow emails will magically appear that show that something was submitted on a day, on any given day, that the other party doesn't have a record of. Say, well, I sent it. Could also be that I don't know of any formal hacking issues that have come to mind, but some of my colleagues have said that their computer systems have been attacked, and they think they're going after some of the information that's held on the servers. So that's something needs to be addressed. And corroboration. Can you have a number of different records that actually say the same thing? As in, the contractor says that, I had this many pieces of equipment on site, and the construction administrator says, yes, I visited the site and I saw these pieces of equipment. And if those records corroborate, then that says that, yes, we'll agree that that's how many pieces of equipment were on site. So now we're going to go to a quick, we'll call this maybe a 7-minute break. So I think it's 2:10 now. We'll take a 7-minute break, if you have questions, please submit them. I'm going to take a break, get a glass of water, and I'll come back and look at some of those questions, and maybe we can get some of them answered prior to starting in the next section, which where we talk about schedule delay. And it was pointed out to me that schedule delay analysis techniques were very much an interest of the group. So we'll spend the next section talking about that schedule delay and delay analysis techniques. Thanks very much. We'll be back at 2:17. Well, hello again. So I'm back. I've got my glass of water, and I see that we've had three chats. Two of them are questions. So I'll put these two questions out there. Firstly, often the contractor is late in this notification. Is it realistic to hold the line on 10 days? It's realistic to hold the line on 10 days if if the project manager's behavior suggests that 10 days is all that the contractor is going to get. I might suggest for project managers at a regular meeting, let's say your biweekly progress meeting, is to bring this up. Is that, look, if you have any claims, if you're thinking of submitting a claim, you need to provide this claim within 10 days of that event or that situation first becoming apparent, or the claim will be dismissed. Unfortunately, the first time that you say, okay, fine, I'll deal with your claim, but it's 20 days after the situation arose. If you go down that road and say, okay, fine, I'll take a look at it, through your behavior, you're saying, okay, the 10 days really doesn't mean anything. There are sufficient cases that get mentioned in the through legal decisions on a regular basis that will back you up. And if you're ever having a conversation with your contractor, you can say, look, I've got these decisions here. It says if you didn't give proper notice and you didn't give it within 10 days, you have no standing, and I'm not going to look at your claim. That will get people, or contractors anyway, in line. The other aspect is, the other question we have, basically saying that contractors often do not want to address time implications at the time of the change order. They put to be determined. I would suggest that, again, as part of that is behavior, how you are managing the contract. I would suggest as you strike that through, put 0. It's like, if you can't figure it out now, then it must be 0. So and put it back to them. Your claim section says that the contractor must identify any extensions of time, and we're just about to address that here. And you'll see some of the ways that you can expect contractors to come and look at time as things go on. But again, I find that contractors, if they say they don't want to address time, what it really means is they can't justify that there's any critical delay to the project that has actually occurred. Lots of contractors are very happy to put down, 4 days, 5 days, 10 days. And it's been my experience usually that those indications of additional time requested get stroked through and somebody says 0, mostly because there hasn't been a proper analysis done. And the contract administrator says, well, you haven't shown me anything, so I'm going to say that it's 0. So I hope that provided some answers for you. So let's move on to schedule delay. Schedule delay is the most common component of claims. Basically every claim has a delay component. Section 7.5 of your agreement addresses the matter of delay to the contract. We spoke previously about criticality of the schedule as a project document. In this chapter of the manual, we dig a little deeper into the mechanics and interpretation of the schedule so that a contract administrator can maximize the use of the schedule as a tool to support or defend a claim. We saw previously the requirement for a properly constructed project schedule cannot be underestimated. It is the basis for developing or defending a delay-related claim. As we said before, what often happens is the project schedule is either A, poorly constructed, or B, rarely updated, such that the schedules cannot serve any effective purpose in identifying or determining a delay to the project. Before looking into issues surrounding the schedule delays as they relate to claims, we'll just remind ourselves of the key principle of any delay claim. The American Association of Cost Engineers, or AACEI, to put the international flavor to it, says that delay must affect the critical path. Before a party is entitled to time-related compensation for damages, it must show that it was actually damaged. Because conventionally a contractor's delay damages are a function of the overall duration of the project, there must be an increase in the duration of the project. And that's from the AACE 29R-03, which is Underlying Fundamentals and General Principles B, related to schedule delay. There are three basic definitions. Two are kind of variations on the theme. The delay to completion date is a delay on the date by which the contractor is contractually obliged to complete the works or, say, some sort of intermediate milestone, whether as a result of the agreement or as a result of the extension of time granted. Now, the delay to the date for completion is an adverse effect on the date by which, from time to time, the contractor intends to complete the works or any contractually defined section of the works. And a delay to progress, this is somewhat different. It's an adverse effect on the date by which, from time to time, the contractor intends to start or finish any identifiable activity, sequence, or resource. So this delay to progress deals with just about anything in the schedule. The previous two dealt with things that are on, mostly on critical paths. Let's just, before we get into this, we'll recall the basic tenets of a claim. Must have causation and the related effects. The other party must be liable for the effects, and there must be damages. If any one of those three is missing, you don't actually have a claim. Related to delay, there must be an event that causes a delay. The delay must be the liability of the owner, and the delay must have caused damages. That would be a owner responsible delay event. Some further definitions regarding delays. There are things called these are all different types of delays. There are critical and non-critical delays. As you might expect, the critical delay is one that affects the critical path and results in a delay to completion. Non-critical delays affect some activities, but do not affect the critical path. Many delays, of course, may start out as non-critical delays, and if they go on too long, they become critical delays. So that's definitely something to be careful of as your project is ongoing. Concurrent and non-concurrent delays. That's something that's in the Canadian legal publications these days. A couple of high-profile cases. Concurrent delay is a term used to describe an effect caused by two events occurring at the same time, one of which is the owner's fault and the other is the owner's fault. Sorry, one of this contractor's fault, one is the owner's fault. Related claims typically deal with the apportionment of responsibility for the concurrent delay. Non-concurrent delays, of course, are delays that do not happen at the same time as another delay. We also have compensable and non-compensable delays. A compensable delay is a delay where the contractor is allowed compensation under the terms of the contract. Non-compensable delays may be ones for which the extension of time is allowed, but no payment is made to the contract. Force majeure delays are examples of non-compensable delays. Lastly is the excusable versus non-excusable delays. Excusable delays are ones for which the contractor is excused and is not punished for the delay. Non-excusable delay are, like they say, non-excusable. Just a couple of rules in assessing how these different types of delays are. Rule number one is if a delay event cannot be shown to be excusable, it is therefore non-excusable. And if a delay event cannot be shown to be compensable, it will be deemed non-compensable by default. The second rule has to deal with excusable and compensable delays. And demonstrating that a delay is both excusable and compensable, the delay must be shown to be critical by reference to a critical path analysis. That is, the critical path is extended on the project. That is the only situation where you can have an excusable and compensable delay. So common types of construction delay. This is a non-exhaustive list. The typical sort of run-of-the-mill things, acts and omissions by the owner, failure to pay. This, we have for the longest time issues of subcontractors not being paid, circumstances beyond the contractor's control, excessive weather. We'll see some of these later. Force majeure, errors and inconsistencies in the drawings. Instructed change. This is basically change orders issued that will, delay the project. Weather. And weather is contentious. It's generally weather that is outside the normal bounds for that location. Unforeseeable physical conditions, generally subsurface conditions. Access to site. Was the is an access agreement required? Infrastructure projects, particularly things like out west, where you have to get an agreement to cross somebody's piece of land in order to build, say, a transmission tower or a pipeline or something like that. Postponement, acts of third parties. See this quite often where, say, third-party utility companies have problems or don't move utilities like they're supposed to. Nominated subcontractors and suppliers, where an owner pre-purchases a piece of equipment and wants to assign the contract to the successful bidder, but then the piece of equipment doesn't show up. Who's responsible for the delay? And delays in receiving instructions. That's a communication issue. But we'll call that a top 12 list. But there's any number of issues that can be a cause for construction delay. How do we manage delay claims, and how do people put delay claims together? Schedules and records. We talked earlier about records, documentation. AECE, when it talks about schedule, it said that every single schedule that's submitted on the project should be part of the analysis. And that's a way of ensuring that all of the information related to schedules is in one place. Certainly the notice of claims, claims that are submitted. Sometimes those notices may not have a time component at the time they are submitted, but it could very well be that there is a time issue related to it. Early warnings, sometimes these come from meeting minutes saying that, this supplier or this subcontractor has been slowed down because these shop drawings weren't returned on time. Those sorts of things can, be something that informs the claim. Now, of course, the duty is imposed on the contractor to give that notice of delay. And as we talked about, the contractor should give written notice of that delay within 10 days of the commencement date of that delay. And that, as we mentioned before, goes to all claims, but particularly with regards to delay claims, because every day that the notice is not given is another day that it could be potentially delayed, and the owner is not able to act because they have not been advised of what the problem is. Want to talk a little bit about scheduled delay methods. The Society for Construction Law and the AECE, which is formerly the American Association of Cost Engineers, are two recognized global institutes that provide clear guidance on schedule delay analysis, protocols, and methodologies. For the purposes of this chapter, we'll be following the general guidelines of the Society for Construction Law Delay and Disruption Protocol. It provides useful direction on measures for dealing with delay and disruption issues. They can be applied in relation to all projects, regardless of complexity or scale. As described in the protocol, there are generally 6 accepted methods of schedule delay analysis, and they generally fall into 2 different categories. One is cause and effect, and basically that means you start with the identification and description of an event or a cause and seek to establish its impact, that is the effect. The other methods are referred to as effect and cause, starting with identifying a critical delay, that is the effect on the project, and then going backwards into the records to try and figure out what may have caused that delay. When there is a discrete owner's delay event and the extension of time application is being made at the time the event is occurring, usually we use the cause and effect methods. It's a proactive approach to addressing the extension of time. In contrast, where the extension of time is assessed, after the work, after the delay, well after the delay is completed or at the end of the project, then the effect and cause methods are generally considered to be forensically reliable because they consider any and all potential causes of the delay incurred, looking back on the job that is completed. So right now we're going to look at different schedule delay analysis techniques because we've been told this is certainly a matter that you as a group are interested in. So I'm going to put a poll up here, and hopefully I can do this without causing an issue like I did last time. So here's the poll that I'm putting to you. There are different delay analysis methods. Should we get the same answer if we use different delay analysis techniques? So again, we're going to go into we're going to look at a number of different techniques using a case study that has some agreed facts. And the facts of the matter are not in dispute. It's what the answer that they come up with. What is that telling us? So we're going to give this just a little while longer, maybe another 10 seconds. So again, the question is, should we, using these, we have different delay analysis methods to be used, should we get the same answer? Okay, so I'm going to end voting in 5 seconds. Okay, 1, 2, 3, 4, 4.5, 5. Okay, so so according to the survey says that what do we have here? So we have 7 people have said that yes, they should have the same answer, and 11 have said no, they could have different answers. So let's carry on with our presentation, and we'll go through this. We start with a look at schedule delay analysis, why we're doing it, and some of the definitions we use. So why would we do a schedule delay analysis? Of course, construction contracts always have to specify time for completion. So if we're not going to make that date, we should be able to analyze why not. For contracts that have liquidated damages, they're always tied to late completion. So a contractor anyway would want to say, look, I was delayed for this reason, and therefore I should not be assessed liquidated damages. Again, as we just said, that delay analysis should be done by the contractor to verify or to justify their request for an extension of time. Many of our assignments are to...
Hi, Kevin, the slides are not on screen.
Again, my apologies. Are we there now?
Yep, they're back up again. Yeah, that's good.
Okay, we're good now? Okay. Okay, sorry about that. Sorry, so you didn't see this first time. So yes, construction contract always has a time aspect. Liquidated damages are always related to time, so you may want to analyze. Contractor should be submitting something, an analysis for its request for extension of time. And we often prepare delay analysis for owners wishing to counter a claim for extension of time from a contractor. Just a note for exceptions for if you have an acceleration claim or a non-critical prolongation claim, these delay analysis techniques don't really apply because you're not actually changing the critical path. As far as justification or verification of whether there's what the substantiation is, it very much heavily weighted on the contractor. The owner merely has to look at the calendar to apply liquidated damages if the project is not finished on time. Let's just look at some of the skill sets of what a delay analyst, what they need to know. The delay analysis kind of fits over top of these various disciplines. Needs to have strong planning and project controls knowledge. Should have knowledge of contract administration. Now they're not legal. They're not legal. They're not lawyers. But they do need to have a knowledge of the acceptance of the methods, understanding of what the law says about concurrency and things like that, and of course their own body of knowledge. How delay actually works, how schedules work, how schedule software works, and interpretation of the documentation. That's their own body of knowledge and how that fits over top of that. Want to talk about 3 basic definitions. You probably all have a very good idea of what these mean, but we just want to look at these just in getting ready for our case study. So we have a network. It's a group of activities that describe the project's scope of work, and they're linked together in their logical sequence. And you can show that as a network like that, or show it as a Gantt chart, something where perhaps we use every day. Want to talk about float, and this is something that early in my career I did not understand. And what I find, unfortunately, is most contractors don't understand, and unfortunately, many delay analysts don't understand. Free float. Free float is the amount by which an activity can be delayed before it delays one of the successor activities. So basically, something can be done at a given time, and it can be done, completed later, but only up to the point that it delays the next activity. Total float is slightly different, and this is the float value that you should really be looking at when you're analyzing schedules. Total float is the amount by which an activity can be delayed before it delays the project. So before it becomes a critical delay. So we're going to talk about float here just briefly. Okay. So let's look at towards the bottom, this piping erection activity has this much free float. and that this activity can move that far before it affects the next activity, which is the piping tie. So this finalizing the piping design, well, it can move this far before it affects this activity. Let's look at total float. So piping erection, again, it has this much total float before, so it can move before it moves the next activity, which also happens to move this activity to the project finish. So this amount of movement would change the end date. Let's look at the next, this award of piping contract. Now it has that same amount of total float in that these two activities can move this far before it affects this project. Now, finalizing this piping design activity, this is interesting. It has this amount of total float because this will move this next activity. And it also has to, well, sorry, my apologies. One step back. The total float for this activity is the amount of movement that has to take plus the amount of movement this one would take as well. So it is actually the combination of these two floats. So this is important when you're analyzing a project schedule. And lastly, the two definitions of critical path. They're similar, but not identical. The zero total float definition, that is the critical path of the schedule is that path with zero total float. So if you look at your Primavera P6 schedule or your Microsoft project schedule, the path where that total float value is 0 is on the critical path. The other definition is the longest path, and that's the critical path of the schedule is the longest path through the schedule. This will have the lowest numerical value for float. If using the longest path definition, if a project is on schedule, you will have 0 total float on the critical path. If the project is behind schedule, you will have varying degrees of negative float. The largest negative value would be the critical path and would dictate the longest line through the schedule, the longest path through the schedule. So, as you can see here, these activities all have total float values attached to them. All of these activities do not. So this is the critical path here. From the Society for Construction Law Delay and Disruption Protocol, second edition in 2017, sort of 4 most commonly used methods is the impacted as planned, and that you put an impact onto your plan schedule. Time impact analysis is a more contemporaneous impacting of the schedule. So it's not, and somewhat different from impacted as planned. There's the as planned versus as built Windows analysis methods, and the collapsed as built, or as built platform, where you start with the as built schedule and pull out delay events to give you and collapse the schedule to give you what would have been the proper finish time. The AACEI has a somewhat more involved description or taxonomy for these, but you can see that basically they come up into some of the same sorts of groupings. So these are all impacted versus as built, or sorry, my apologies, as planned versus as built types of analyses. This is the impacted as planned. This is the time impact analysis, and this is the as built but for. But some of the things, the terms that we should keep in mind. These are all observational techniques, and that these are all looking back at the overall project. And these are all modeled in that these can be, these don't necessarily use the full detailed information from the project. And under sort of a subcategory of these, they're called static logic and dynamic logic. I'll leave that for you to think about it. And these modeled projects, these are additive, in that you add delays, and these are subtractive, in that you take delays out of the system. So we have a little case study here where we're going to be able to show you some of these different delay analysis techniques. So we're at the end of the job, and the parties agree to these 4 delays. So both parties agree that and these are all owner caused. So the owner has delayed access to the site by 10 days. The owner changed the foundation design, and that was 30 days of additional work. The owner requested a rerouting of pipe for a 54-day delay, and the owner provided a valve to the contractor in different intervention. So there was a further 6-day delay. So the 2 parties agree to this. These are not in question. But let's look at, and this is the schedule, the baseline schedule that they agreed to at the start of the job. This is the critical path. And this is the as-built schedule. So this is what happened at the end of the job. And these are the 4 delay events and where they occurred on the project. So that's that 10 days. Okay, so now we have, in this particular, oops, my apologies. This is, so we're going to use 5 different, we're going to look at 5 different methods as we look at this. Now, the impacted as planned, the as-built but for. Now, this is actually a time slice windows analysis because we're looking back at a finished project. And then we have 2 of the as planned versus as built. So let's take another look at these. Oops. Excuse me. That should not have happened. So what do we need to have for the impacted as planned method? So to use this method, what we need are the agreed baseline schedule, which we have, and we need the list of delaying events. We have those 2. These other 3 categories of information, we don't need them. So if we have the baseline schedule and a list of delaying events, we can use this method. So here we go, impacted as planned. If we put that first delay in there, we move this out 10 days. Now, if we go to the next delay is a further 30 days. So that moves this out another 30. So 40-day delay. Then we have these 2 other variations, 54 and, oops. So we have the 54 and the 6-day variation, but that doesn't actually move anything any further. So we end up with 40-day extension of time. So think of that, impacted as planned. We have the 10 days here and 30 days there, extends the critical path with 40-day extension. Now, the as-built but for it, what do we need for that? We need the as-built but for. So we need the as-built schedule update. We need the list of delaying events, and we need some of the project records to support the activity dates. So when do these things actually occur? What actually occurred? So let's look at that. So we start with the as-built project and we work backwards by taking out the delays. This is when the 4 delays actually occurred. We take this delay out and it pulls the project back by the 6 days. So there's the new code. Now we take the 54 days out. So that's 60 days. And this is still the longest path because that actually has floated. So we take that 30 days out and that moves this back, doesn't change this one. And now we take out the 10 days over here and again pulls that back, doesn't change this path. Oops. My apologies, animation timing is a bit off today. So the as-built but for method gives us 60 days of extension. But using the other method, we just got 40 days. Okay, so this is interesting, to say the least. To use the time slice windows analysis method, what do we need in order to work on that? So we need the agreed baseline schedule. We also need the regular progress updates. So we need to have those. And again, we need that list of delaying events. But we don't need the final as-built. And we don't need the detailed project records. Okay, so let's take a look at this particular thing. Now, time slice, we look at this in Windows. So we're going to look at this 3 months at a time. That window period can be different depending on the project you're looking at, how long it is, how complex it is. For this analysis, we're going to use the 3 months. So in this case, in the first 3 month section, the main thing that happened to the job was that the site access was delayed by 10 days. So there it is. You have the first 3 months. What activity happened was the 10-day extension. So after the first period, we have an extension of time of 10 days. So in the second update, we have the piping design was completed. Well, that's good. The award of the piping contract was slow. It's still 1 month forecast to complete the piping award. And we have within this period that 30-day variation for the modification of the foundations. So let's take a look at the next window. So there is 30 days. So that gives us 40-day extension of time. So we had that first 10 days here. The next 30 days there, we have a 40-day extension of time. My project update, the third period, so months 6 through 9, or from month 6 to month 9. So the changed work is completed. The piping contract is awarded, but 2 months late. The tank construction starts, and we have that 54-day variation to reroute the pipe. And now just a comment that's a bit ahead of the schedule, but the pipe, you'll notice that the pipe erection is still not critical. So let's look at the next thing. So here we have that 54-day extension of time. Oops. So the 54 days has extended this activity, but it's still not critical. It is still not pushed the end. So even though we've added 54 days to this activity, we still have only an extension of time of 40 days. So let's look at the month 9 through 12 progress update. So we have the tank construction is complete. The pipe erection is delayed due to poor subcontractor performance. And again, the comment that we have here is that the pipe erection is now critical. So let's take a look at this one. So we've put in this piping erection is still not done, and it's critical. But we haven't had that my apologies. We haven't had any other delay events. We still just have these 3 delay events. We still only have an extension of time of 40 days. The fact that this is extended is the contractor's fault. So there's no additional extension of time allowed for the contractor. So now we go to the last progress update, which is month 12 through 15. Further poor piping subcontractor performance. And we get that 6-day award due to the 6-day extension of time due to the valve specification. So here we get into that last section. We add those 6 days. Now it moves the critical path by 6 additional days. It was 40 days before, now it's 46. Look at that. Sorry. So we get to month 15, the project is done because the project completes at the end of month 14, which is 4 months late. So this is the final as-built schedule. So we have these 4 delays with an extension of time of 46 days. So this is interesting. The first analysis method had 40 days. The second was 60 days. And this one is 46 days. So let's see, we have two other methods. We're going to look at variations on an as planned versus as built. So we have the agreed baseline schedule, and we have the completed as built schedule updates. Those are the only 2 documents one needs to take to use this method. You don't need the rest of these things to start. So we look at, as we said, gross method 3.1. So we've put these delayed activities in here. These 3, so this one aligns with that 10 days from before. And this one aligns with the variation of 30 days that we talked about. Now this one here, we've looked at the documentation, but it doesn't show any employer event, any owner event. And within this one, we have 60 days total. So this gross method 3.1 shows an extension of time of 60 days. Now let's look at the contemporaneous as is method. So again, the as-built schedule, the 10 days for the delay, 30 days, so it's a 40. So there's no delay there. So we looked at this first. So that's where 54 days would happen. Okay, so that's when that happened. Now we look at the remainder of the project. So that's a delay that happened here. But within that time frame, we had 6 days. So you get an extension of time of 46 days. So in a quick, we've tried not to take too much, whoops, I can't find. So a comparison of these results. So we've looked at 5 different analyses, and we've come up with 3 different answers. And this is based on 4 delays that both parties agree occurred. So there's no animosity between the parties as to that. It's just a matter of, we've done these different exercises. And we've come up with 3 different answers: 40 days, 60 days, 46 days, 60 days, or 46 days. So why would that happen? Why do and of course, we're looking at work that's done theoretically by experts that are retained. And this goes to, and this is usually a matter when it goes to court or to arbitration. So why do these opinions differ? Well, as we just saw, different delay analysis techniques end up with different results. Critical path method limitations. Sometimes the method is too simple for the situation, and sometimes it's too complex. Now, one thing that I want you to think about is, in this examples we had before, is what happened to the critical path as we went through the project. And we'll talk about that just as we come to the end. Sometimes the assumptions or the interpretations and experience can have an effect on what the analyst thinks about it. It's their experience. They may be more comfortable with something, with one method over another. Conflicting records. It could very well be that some of the records that the contractor will use doesn't match with the records that the owner would use, and sometimes they're in conflict. Sometimes it's just a very poor application of the method. They may have selected one that they're comfortable with, but it's simply inappropriate for the situation. And one thing regarding experts, and something that we strive at Driver Tret every day to be certain of, is that we don't want to be hired guns. We don't want to be there to provide the answer that the contractor is looking for. We want to be able to provide the answer that the information leads us to. That type of analysis will be the one that stands up best in court. What is going on here? Okay, just talking. This is a table from the Society for Construction Law, and it highlights some of these different methods. Impacted as planned analysis, time impact, time slice windows analysis, as built versus as planned, and collapsed as built at the bottom. We talked earlier about cause and effect versus effect and cause. So you have the impacted as planned, time impact analysis, and the collapsed as built are all cause and effect. And the other ones are basically effect and then cause, and that you're looking backwards. If you go to the fourth column, the delay impact, whether it's determined prospectively, as in looking forward in time, or retrospectively, looking backwards. Sometimes, and we'll talk about this in a second, it may be inappropriate to use a particular analysis because, like in the case of the impacted as planned, it's a forward-looking analysis method. But if you're at the end of the job, you're looking backwards at it. So it's really it's not appropriate. The critical path determination, and this is basically what the difference is between the various methods. Impacted as planned looks forward to predict the critical path. The collapsed as built, on the other hand, at the bottom, it looks backwards to determine the critical path. We have the three in the middle. Those are determining the critical path contemporaneously. That is, at the time that the analysis is being made. So now if you look back at that table, the impacted as planned had the shortest delay time, and it was looking prospectively at the critical path. The collapsed as built was looking retrospectively at the critical path. It had the longest time period. The time slice windows analysis, yes, looking back at the critical path, but a contemporaneous critical path of 46 days. I would suggest that if you have sufficient documentation, it would be best. It's not always 100% certain, but it would be best if you have the documentation at hand to use one of the methods that determines the critical path in a contemporaneous fashion. That will get you closest to what the correct answer is. So which method to choose? Again, consider the contract conditions and requirements. Sometimes the contract says you will use this type of analysis. It's generally within a contract that is looking forward, looking prospectively. It will say you must use impacted as planned or a time impact analysis. Records availability and reliability. Again, if you have lots of records and they're reliable, they match those the various qualities we talked about before the break, those are good. Sometimes the value of the dispute, if it's a very low value dispute, you don't want to use an involved method and spend a lot of money. On the other hand, if it's a very high value dispute, you may want to spend money, do a more detailed analysis. Again, and complexity of the dispute. If it's very straightforward, you can use a straightforward method. You can use a more detailed method if you need to, if it's a more complex issue. Time available. Sometimes you only have a few weeks to do this analysis, so you want to use one of the more straightforward techniques. The expertise of the analyst. We spoke earlier about the experience and the background. The forum for resolution of the dispute and the audience. We'll talk later on about adjudication, but adjudication is a very fast process. If you don't have much time and you have a knowledgeable adjudicator, you may use one of the more straightforward methods. If the audience is a seasoned construction arbitrator, you can use a different method, perhaps more complex. If it is a judge who, to be honest, in many locations may have been doing family law, the month before and is not an expert and doesn't have a lot of experience with construction disputes, you may want to use something that's a bit more straightforward. Legal or procedural requirements of the case law. Sometimes the case law will lead you in a direction as to what's best. In the end, you want to use the most practical and common sense approach, given the circumstances. Just summarizing the how to select a method. Again, the methods are dependent on the results are dependent on the method selected. We had 3 different results from 5 different methods. They're highly reliant on the available information and the time and money available. If you have good project management and good controls, you can use it gives you more selection of methods. Obviously, early preparation saves time and money. If you get all your records in place, common sense and transparency, it's basically straightforward. One of the things today is that we find sometimes is that schedule delay analysts have a lot of theory. They know how to run Primavera, but they haven't actually been on the construction site, perhaps don't really understand construction. You really need to rely on fact. And facts, as we spoke of before, fall out of records. If something happened on a given day and it can be verified in 2 different ways, that's a fact. Just because somebody had a thought about something or said something doesn't necessarily make it a fact. Again, we talked of the prospective and retrospective analyses. This also falls into this previous question about, the contractor or perhaps the contract administrator doesn't want to deal with it prospectively at the time and look forward to what the change in the contract completion time might be, change in the critical path. Again, I mentioned the contractor only has to use reasonable means to mitigate a delay. I just had a client who said, there was any number of things that the contractor could have done to mitigate the delay, but they didn't. Well, many of the things that the client listed would have cost a tremendous amount of money to the contractor, and they were under no obligation to do those things. I mentioned, just for knowledge, is the information, a Canadian approach to delay concurrency. There is a feeling that in Canada we sort of apportion delays between the parties rather than just saying yes or no, and that has mostly to do with the fact that concurrent delays, to be precisely concurrent, both delays have to happen at exactly the same time and have the exact same duration, which is next to impossible. So we're about to take a break, and I'm sure you have lots of questions. I'm tempted to maybe ask Patrick that maybe we can arrange a separate session on schedule delay analysis in the future. I'd be happy to put something in front of everyone that goes into those delay analysis methods in more detail. Again, so it's question time. Please use the chat function to ask some questions, and we'll take just a short break now. Again, so we'll take a break, and then we'll get into the last part of the presentation that talks about damages and moves on through to dispute resolution and adjudication. So it's I have 3:12 on my computer, so maybe we'll call it 3:20. We'll reconvene. Please, not getting many questions, and could really use some. I know that Q&A was definitely a requirement here. So thank you very much. Thank you for bearing with me. I know it's a tremendous amount of information. So we'll be back at 3:20. Thanks. Okay, welcome back. So I think we'll just get on to some of the questions. We just only had a couple of questions here since the last break, and first one I think is quite telling. It's how do we encourage better or more effective baseline schedules? The issue with baseline schedules is that many people, contractors, project managers, project coordinators, owners, don't really understand what a proper schedule entails. And there's a sort of a review that most consultants can do, and we would call it a health check. What is the health of the schedule? And now the AACE has a very in-depth protocol for looking at doing this health check. But some of the, if your project is not that complex, some of the main things that you want to look at are, basically, does each activity have a link to a predecessor and a successor? That is, you can't have an activity that has a start or end date that's not linked to something else. There are two, and there are only 2 points in a project that can actually have that condition. One is the start milestone. So it obviously has nothing before the start milestone. So the start milestone only has successors, and the finish milestone only has predecessors. Every other activity should have a link to its next logical activity. The second thing is to not use constraints. And that is, quite often a contractor will say, well, I want to start on this particular activity on this day. So the scheduler goes in and says, okay, starting drywall on April 15th. That the overuse of constraints will affect the ability of everyone on the project to see what happens if something is delayed, particularly on that line. If you use a constraint, it will have an effect. So that is something to be avoided. Another thing that one should use is a proper calendar, a working day calendar within that schedule. Make sure all of the holidays are non-working days. Statutory holidays. You might, if in some provinces you have a stop work period, like in Quebec, they take 2 weeks off for construction holidays. Sometimes, like in Western Canada, they will not work for 3 months of the year, so they have a work shutdown from, say, December 15th to March 15th. Some people will put that simply as an activity that has no work in it, or they'll try to work through that. What the more proper way of doing that is to have your calendar be in that period be a non-working day, so an activity can pass over that period. So that means if you have any delays ahead of that, they'll be properly reflected in the rest of the schedule. Okay. For a complex project, I would recommend retaining a third-party schedule delay analyst to take a look at the project, do a health check, get a report back. We do some work on major projects across the country, multi-billion-dollar projects, and for about $9,000 per review. We do quarterly reviews. We're working on a hospital project now that's a $2.5 billion job. For $9,000, 4 times a year, we've managed essentially to avoid any delay claims because we can always pick up what's wrong with the schedule. Of course, the other thing is if you have a poor baseline schedule that's been submitted by the contractor, you can simply refuse to pay them for it. Sometimes that's the best way to do it, is just be straight up saying, I'm not paying you for it. It's not a good schedule. The other question we have here relates to the software. Is Primavera the only acceptable scheduling software to use? What about Microsoft Project? Primavera P6 is perhaps is certainly at the top of the pile. Is very powerful. It can be very difficult to use at times, so it takes real knowledge on how to use it. Microsoft Project is relatively easy to use. Unfortunately, it's also very flexible, and perhaps too flexible, in that it allows the person using it to basically to do things they really shouldn't. Also uses some non-typical terminology. They refer to float as Slack, and sometimes in using just one example, and sometimes in using that they get some things wrong. So, but Microsoft Project is quite a suitable software for projects that are not too complex, but still the same things apply. You can do the same health checks on using whatever type of software you have. In Europe, there's a software called Asta Power Project that is quite commonly used, very similar to Primavera. So on that note, we don't have any other questions, so we'll get into the very last section of our presentation for today. And I hope that I'm going to keep an eye out here. If for some reason the slides don't move, can somebody send me a quick chat right away, and I'll make sure we don't get too far. So we're going to talk about damages. Chapter 9 of the manual talks about damages. And this is really where the rubber hits the road. Everything up till now, we've talked about cause and effect. Damages reflects the money or compensation that a contractor desires to get from the owner. Damages are essentially the costs that a party incurs as a result of another party's breach of contract. Generally speaking, the breach will be material in nature. That is, the term or condition is fundamental to the successful execution of the contract, and therefore the consequences of the breach would be significant. As we discussed earlier, the idea of a claim is not to unjustly enrich the claimant. It's only to make itself whole. The penalty doctrine comes up in this. It's particularly applicable in cases where the amount of liquidated damages levied against a party is at the heart of the claim. That is, mostly the contractor has been delayed and they don't want to be paying these liquidated damages. Again, the idea of that these liquidated damages should not be a penalty. Okay, let's look at direct damages. Damages themselves fall under sort of three categories: direct, indirect, and liquidated damages. Direct damages are damages that can be considered to flow naturally from the breach of the contract. This is in contrast to indirect damages, which are further removed from the direct impacts of the breach and are more difficult to logically link to the breach. Consequential damages are damages that are an indirect consequence of performance or other material breaches of the contract. They're described as indirect losses. They don't stem directly or naturally from the breach, but are sort of a knock-on effect. Often these are excluded as damages in a contract. That's theoretically what constitutes a consequential damage, is very broadly interpreted and thus difficult to limit in scope. Liquidated damages, as we discussed before, are a genuine pre-estimate of the direct damages both parties agree would be reasonably incurred as a result of the project's finish beyond the scheduled date for substantial performance of the work. It's written right into the contract. We have a previous discussion in Chapter 5 on liquidated damages and how they apply in your contract. Prolongation. Generally, this is an extension of time, so the contract is prolonged. So prolongation expenses, what sort of costs are we looking at? So these are the types of costs that the contractor could see. More hours for labor, so more additional overtime or premium pay if they have to try to mitigate the damages. Market rate increases if a delay is long enough that work now falls into the next labor rate period, which I believe in Ontario resets on May 1st. That could be a problem. Loss of efficiency or productivity. Those are things where the work itself there's not any more work, but it's somehow taking longer or produced less effectively. Equipment, so on site more often, it's not producing, digging up dirt as effectively as it should. Might need more equipment, materials. So prolongation costs, if you have an extension of time of a contract, the material that you're actually buying may go up in price. And we're seeing that now with supply chain problems with sometimes equipment and material coming from overseas. So that may mean a requirement to use more expensive material. All of the contractors, subcontractors may be incurring these exact same costs. Of course, there's also extended field overhead costs, extended home office overhead costs. And then the contractor itself will be seeing extended field office overhead and extended home office overhead costs. So it's can be a very long list of prolongation costs. Let's look at field office overhead and home office overhead a little bit. And those can be, if a project is delayed, you may need to get more of a resource. That resource may need to be there for a longer time. And of course, all of your general conditions costs, trailers, utilities, snow clearing, things like that may all go up if you have a prolongation of a project. Home office overhead is something that is not fully understood by most people in the business. Each project or a construction company and every company obviously operates to make money. Construction companies, yes, you can operate out of a truck with a cell phone and a portable printer, but most construction companies have a head office or a regional office, and those offices are supported by essentially charging money to each of the projects that they're undertaking. So a project that is extended may not have any additional money being paid to it, but it is incurring home office overhead costs. So again, some of those costs may be increased. You may have, say, more accounting support required to deal with this. Then the additional time you have that project is going on longer, so it incurs more costs or is attributed more costs from the home office. There's also the question of lost opportunity and profit. This is an interesting matter within Canadian case law that we're going to talk about in just a second. And what's mostly interesting about it is that it has to do with the City of Toronto. It is actually the Toronto Parking Authority and Ellis Don. So let's just look at that for a minute. The loss of profit, and this case goes for Ellis Don versus Parking Authority of Toronto, 1978. It's actually for a parking garage in Yorkville, which has just recently been demolished to make way for condos. I'll start by saying, number one, it's difficult to prove because it requires very thorough and diligent record keeping by the contractor related to how it bids work and the tenders it submits. In the end, the capital, the company's capital, its human and equipment resources contribute to the company profit. And if it's not deployed, if it's not out there earning its keep, the company doesn't make its regular profit. So what did the judge find in this particular case? So let's, bit of an example. Let's say that our theoretical company usually performs $200 million of work annually. To get that work, it has to bid up to $1 billion of work. So its success rate is 20%. That company regularly makes 5% profit. Again, we're looking at an example here. Could be higher, could be lower. In our case, the company wins a $50 million project. So that's 25% of its annual work. And the expected annual profit on it is 5% of that 50 million, or 2.5 million. Let's say the project gets delayed by 9 months by the owner. But the 9 months isn't known at the start. It's simply that it's a delay. So the company can't redeploy its capital and staff and equipment because at the start, it doesn't know that it's how long the delay is going to be. And as we know, the company is only getting only successful 20% of the time. So it can't immediately go out, get work the next day, and reassign all these resources. In the end, the judge said that through his formula that the annual profit is reduced by 9 months out of the year at 5% of $50 million, or 1.875 million. So this is certainly an owner cause, an owner issue. So an owner needs to have all of the permits, building permit for sure, but if other third-party work needs to be done ahead of time, things like utility relocates and those sorts of things. If that is all on the owner's table and they are late in that dealt with, it could be on the hook for some significant funds related to loss of profit. Again, it's very, very hard to confirm entitlement. They must have detailed records of their annual bidding activity. They would also have to show their records of their profitability, which most private companies are loath to do. And it also needs to show that it had the ability to bid other work and did not bid because they had secured that project in question and they couldn't redeploy their staff. So again, difficult. So some companies will say, "Oh, I lost profit," but it's a very high bar to jump over to get that money. And one last thing about damages, the duty to mitigate. And the contractor is always, number one, the owner can mitigate its damages if it receives timely notification from the contractor. So that's one of the issues, or one of the important aspects of notification, is it gives the owner the opportunity to mitigate its damages. Now, related to the contractor is under no obligation to actively reduce the damage. It simply needs to make reasonable efforts that any losses are not unjustifiably increased. So they don't have to go over and above the call of duty to mitigate or reduce the owner's damages, but they do need to make take reasonable actions. Determinations. We need to talk about the contractor's determinations. So section 2 of the Schedule D of the contract has these things that you really need to be aware of. Contract administrator is, in the first instance, the interpreter of the requirements of the agreement. So the contract administrator has comprehensive oversight over the project. They're charged with making the majority of determinations when a question arises respecting the interpretation of the contract. Interpretations and findings of the contractor shall be consistent with the intent of the agreement. That is, they are not to show partiality to the owner or the contractor, even though it's the owner that pays the contract administrator's fee. And quite often contractors will say, well, I expected that decision. The contract administrator, which in many instances may be come from the same party that produced the contract documents, the drawings and specifications, Contractors rarely, or I often find that it's a contractor's opinion that the contract administrator has not been fully impartial. Oops. The 2.2.10 talking about giving those interpretations in writing. We saw earlier that they talk about 90 days for a determination of a claim. So again, the 90 days in my mind, this is just my opinion, is pushing the idea of reasonable. And it's the contract administrator's job to investigate all claim notices made by the contractor, as set out in 7.7, and make findings as set out in 7.7. So again, this is the contract administrator's job. They're to perform that function impartially. Again, going to 7.7, in the case 7.7.5, contract administrator doesn't have to rely strictly on what has been provided by the contractor. They can ask for additional information. Okay, so there's no, they don't just have to say, well, you had your one chance. If additional information is useful and useful to the overall contract, then the contract administrator can request that within 30, and the contractor must provide that information within 30 days. Again, we talked about this 90-day timeline for determination. And the last aspect is, once the determination has been provided, the contractor has 15 working days to either submit a revised claim notice or start the dispute resolution process, or the determination is concluded as agreed by the contractor. We're going to talk a little bit about dispute resolution. If the parties aren't able to address the matters through the processes within the contract, you end up at dispute resolution. That's all dealt with in section 12 of the Schedule G of the agreement. Contract. One of the points that we should be making is that the contract administrator again mentioned that it needs to be impartial. If the contractor believes that they are being impartial, they can refer to the dispute resolution process to have something looked at again. So it's something that the contractors need to be aware of. And as project managers, I think you also need to be aware that again, you may not agree if the contract administrator finds in the contractor's favor, but you need to watch that your contract administrator is being impartial. Related to dispute resolution, one thing that we need to talk about is continuance. Just because something has moved into dispute resolution doesn't mean that the contract stops. In fact, the contract itself calls for the work to carry on. For this reason, quite often when something moves to a dispute, the matter is basically taken away from the parties that are dealing with the project. So the project managers, contractors, it moves into the head office to get it away from the day-to-day operations, so that the work can actually continue on. We do have in Ontario now this availability, or to use adjudication as a means of resolving disputes on an interim basis, an interim binding basis. We'll talk about adjudication later on. And again, dispute resolution does have this fallback onto claim notice validity. Has the claim notice been submitted in a timely fashion? Has it been submitted in accordance with the contract? And here, of course, we have, for most claims, it's a 10-day notice period. Some aspects that may eventually lead to claims, like subsurface conditions, have a 5-day time frame. So need to be very careful about these. There was a question previously as to the contractor rarely meets these timelines. Well, if you're consistent in rejecting issues that don't meet the timelines, the contractors will learn eventually that they need to meet those timelines. Quite often, there might be multiple notices on a job. If the first one gets thrown out because they were too late, you can rest assured that most of the other ones will be submitted on time. The basic dispute resolution path, of course, if you've gone past the project and now you've moved into more senior personnel looking at senior managers looking at this, you will start with negotiation, and you work on to if negotiation fails, you're not able to come to an agreement. Usually by contract, you go to mediation, where you work with a mediator to try and flesh out the real issues, and perhaps the parties can come to an agreement. Now that we have adjudication in place, as I see this slide now, perhaps that should be mediation and adjudication could be one above the other. There's two separate paths, but we have the opportunity for many matters, statutory legislation that allows a contractor or an owner in some situations to instigate an adjudication process. If the adjudication, if you take that on for a matter, the determination from the adjudicator is interim binding. That is, it's binding to the end of the job. It is still possible to look at that issue again, and in the contract that you have, it's either it's through arbitration, or if for some reason a lien is placed on a project, then you would go through the courts through litigation. We want to look at adjudication in a little bit more detail. I know that you have, or I've been informed that you've had some training in this, and that you certainly have a number of resources available for dealing with adjudication. But just want to sort of circle back on this. Driver Tret being based in the UK, we've been working with adjudication for a number of years. I've actually worked on some adjudications, assisted the teammates there, partly because they needed resources, partly because I needed to sort of dip my toe into adjudication and how it actually works. So the adjudication was brought into construction in the UK in the mid-90s as a means of pushing, greasing the wheels of payment. Money was not flowing from owners to contractors to subcontractors to suppliers in a predictable and ready fashion. So they brought in the idea that an independent third party would look at a matter in a short period of time and make a determination that would hold to the end of the project. If the matter really needed to be looked at again, it could be. After a bit of a slow start, essentially, probably 80% of things that we would call a claim are dealt with through adjudication. And the history with adjudication in the UK is that matters that are determined by an adjudicator are not relitigated. They're not looked at again in court or by an arbitrator in 95% of the instances. So for most intents and purposes, the decision of the adjudicator is final. The adjudicator prompt payment legislation in Ontario that came into effect in October of 2019 sort of fits hand in hand with adjudication, in that if payment is not made properly, a party that has not been paid or has been told that they are not going to be paid part of their invoices can raise the matter through adjudication and have it addressed promptly. The prompt in this case is a matter of, I think it's about 6.5 weeks. In a standard time frame, it would be 46 days. In Canada, more and more jurisdictions have introduced not only prompt payment legislation, but adjudication or legislation that allows for resolving those cases through adjudication. The federal government has that legislation in place. British Columbia, Alberta, Saskatchewan all have legislation on the books of one sort or another. Manitoba had it, but it got dropped the last time they had an election. It's available in a small way in Quebec, and Nova Scotia has legislation on the books, but it has not been in no other actual jurisdiction has it received royal assent, so it's not actually in place just now. Again, we talked the reasons for success of adjudication, at least in the UK. Looks at the quality of the adjudicator. They tend to be engineers, architects, lawyers, claims professionals, so parties that have a interest in the business and experience. It shouldn't be looked at, sort of arbitration light or mediation light. It's a process unto itself. It's a very time-intensive process with a very short time frame. Adjudicators are provided by a nominating authority. In Ontario, it's called ODAC. And they need to make sure that there are a sufficient number of experienced and qualified adjudicators available to deal with the wide range of matters. Of course, the matter, just like the contract administrator, should be operating impartially. The adjudicator also has to be operating impartially. That's one of the very few ways of having a determination thrown out, is if one party can show that the adjudicator is acting impartial, with partiality to one side or the other. Now, as far as in your situation, the city has set up a corporate adjudication team. So with lawyers and legal expertise. If for some reason you receive a notice of adjudication, you need to contact them promptly. And what will support dealing with an adjudication is a solid file organization. It goes back to documentation. The other saying they talk regarding documentation is the party with the best documentation wins. And best usually means the most, I won't say most complete, but a complete set of records that will fill in the blanks that the other side has either doesn't have the information or has chosen not to identify. I have a bit of question and answer related to the city's procedures that we'll go through. Does adjudication apply to every contract? No, it doesn't. Anything signed before October 1, 2019, it doesn't apply, guaranteed. Some contracts were signed after October 1, where the procurement process was started before October 1. So if a procurement process was started before October 1, the current legislation does not apply. If it's not clear, again, go to cat@toronto.ca and they should be able to assist you. Some of the questions that will arise or in parts of the process. Is there an entitlement for the parties to resolve a dispute through adjudication? There's the parties can deal with adjudication for valuations of the services or the materials, the payment under the contract, set-offs for whatever reason, and holdback payments or non-payment holdback. Those are all by statute matters that can be processed through adjudication. The last and sort of general encapsulation is that any other matters that the parties agree can be adjudicated. That can be written into the contract ahead of time. It can be added afterwards and would be through a change order. So, or to be quite honest, if the two parties say we can't come to an agreement on this, let's agree to use adjudication, then the parties can agree to do that. let me see. Is adjudication the right method of dispute resolution? Sometimes if something is of a very small value, it doesn't make much sense to spend a lot more money getting an adjudicator involved and spending a lot of time pulling things together. So, the parties should consider whether adjudication is the right method. Even if one party has started the process, you can still negotiate later on. So preparation and service of the notice of adjudication. While it doesn't have to be too complicated, there are some very specific requirements. Have to have a name, address, name of the company, the address, the contract number, and the description of what the issue is about. Selection and appointment of an adjudicator. The legislation allows the party that is starting the process to nominate or put forth a proposed adjudicator. The recipient of the notice has two choices. One is to accept the adjudicator that's been put forward. The other is to say no. And if the process continues, the adjudicator will be appointed by ODAC, which is the nominating authority in Ontario. There's no opportunity to nominate another individual to do this, to be the adjudicator. Of course, prepare the adjudication framework. A lot of that has to do with making sure that the documentation is in the right place and the right documents are there. Certainly work with CAT to pull those things together. If you're looking at, if an adjudication might be coming, if you know that there's a dispute that the contractor is considering going forward with adjudication, you would want to start by setting up a separate folder and putting information there. One thing that you need to watch out for is, again, the type of correspondence that you're creating and that you're recording. I understand that been advised that there's an application called Jabber, which I did not know about until I started working on this assignment. I guess that's a texting system, in-house texting system. That really need to make sure that you're not sending actual documentation. Don't rely on Jabber, let's say, to provide the documentation you need to back up or to support your position or the city in an adjudication. As far if you were to receive a notice of adjudication, so you need to decide if the adjudicator, we just talked about, if the adjudicator is reasonable, you're going to either accept one or take what you get, or take who is assigned by ODAC. So you start to lose control with this if you put it back to ODAC. You need to explain the issue being what the deal is, what the process is, or what the problem is, rather, with CAT lawyer that's assigned to that document. FAQs, frequently asked questions. Can the city refuse to pay an adjudicator's determination even if it's wrong? No. The process is you need to pay it, and then you need to go and either relitigate at the end of the job, or if you have a problem with the adjudicator themselves, then you need to go to court and say that the adjudicator was biased. As far as the process for payment of the adjudicator's fees, those fees are payable in advance of the adjudication. The manual outlines dealing with the accounting to actually get that paid. Again, what's the process for payment once the determination is made? Again, you can go to accounting for that. I believe, as far as the contract goes, a change order is most likely in order to be added to the contract. Can the city negotiate a settlement of an adjudication with the contractor? The city and the contractor can negotiate up to the up to the point where the adjudicator makes its determination. Once the determination is made, that determination must be paid. If the parties come to a negotiated settlement ahead of the determination being made by the adjudicator, that's fine. You simply advise the adjudicator that the matter has settled, and that's the end of the issue. Additional resources to assist staff. Again, go to talk to Kat at toronto.ca. As far as additional resources, I'm happy to take calls, take emails. Kevin.O'Neill@drivertret.com, and we can help if you have any questions. And with that, I believe we've come to the end of our presentation. I thank you, everyone, for your attention, for your participation, for sticking with us. I know it's a tremendous amount of information submitted or put to you very quickly. If you have any final questions, I'm happy to take them. We'll leave the presentation going here for probably another 15 minutes. If you have any other questions, please use the chat function and send them in, and I'll try and answer them before we go. If we're not able to do that, we will be sending out questions or answers rather to your questions to Patrick. We'll have a sort of a formal response to all the questions that everyone has submitted over time. I see we have one question that came in a little while ago. Are resource-driven related to schedules? Are resource-driven schedules best practice for lump sum projects? I think a resource-driven schedule is a best practice, period. Generally, I would consider it a best practice for the contractor because it helps them understand the resources that need to be in place on any given day, and how much that is costing them. Often we find that specifications are written to say resource loading specifically for that point. It's a nudge, let's say, to the contractor to make sure that they understand the work that they're doing, and that they really should be doing it. Now, whether you for lump sum projects, it's certainly the lump sum project is a lot more common here in Canada than it is, let's say, in the UK, which has a very, how should I say, a quantity surveying orientation. Basically, is like, we'll tell you what to build, we'll give you an idea of what we want built at the start, but the final bill of accounts will be settled at the end of the job. Rather than here, we're saying we understand what we want built and we want to do it with one party at the lowest price, which is the lump sum. At that point, it puts all the responsibility on the contractor to organize themselves properly. Again, if they used resource-loaded schedules properly, it would be to their benefit. But it's not. I don't know that it's really. I don't know that it's a requirement. If a contractor were actually to submit a resource-loaded schedule or prepare that resource-loaded schedule, and it was approved, it would serve as, or could serve anyway, as a basis of their own claim against the owner. But I would say that's not necessarily the reason for not asking for it. It's a good thing to have. Of course, I would also say that your contract administrators, project managers, project coordinators, many of them, not to denigrate them, they don't have the specialized knowledge to understand what that schedule really means and what's there. Now, one assignment that DriverTread had was for actually a fairly small contractor doing a project for the TTC. And the TTC project manager was being very literal in dealing with schedule and payment, and said, you're not getting paid until I approve the schedule. And they came to us after about 3 months and saying, we can't get the schedule approved. So we put a schedule, we helped them put the schedule together. It was not, it was very cost effective, because after that, every time they made a submittal for payment, they were paid immediately. They were able to easily update their schedule. I believe it was actually in Microsoft Project. It was fairly straightforward. They would update the schedule, and we were told afterwards as they used that in putting forth a claim for delay on an issue. It was only a couple of days or something, but because they had a fully formed schedule in their possession, it was a very straightforward process. So, okay. I don't know, people are being shy about sending questions in. So, so maybe on that note, I guess we're done. So I'm going to leave the application running for about 10 more minutes. Feel free to submit some more questions if you'd like, and we'll get them answered and get them back to you. But thank you very much for your attention. I know it's, again, a tremendous amount of material to go through. Thank you very much. Everyone stay safe.